I appreciate you having me. I really appreciate the Chamber for having this series. I think it's timely information that we can all benefit from. This particular topic was something I wanted to talk about because I have a lot of friends and clients who run nonprofits and small businesses who haven't been paying attention to the Families First Coronavirus Response Act because they assume that it doesn't apply to them. And these are typically organizations with less than 50 employees who aren't normally subject to FMLA or the Family and Medical Leave Act and may or may not have paid time off for their employees already in place. So hearing that had me concerned that there are some people that might find themselves out of compliance and may be subject to this. So in today's webinar, we're going to talk about an overview of this FFCRA and how you know the extent to which it applies to you and your business. And I'm really excited that we have two attorneys with us from Par Ritchie. We have Aaron Borisoff and J. Michael Deweese, and I'll have them introduce themselves in just a moment. And they can answer very specific legal questions that you might have. There are probably going to be some tax and accounting questions that come up. We don't have, unless there's somebody here who feels comfortable answering them as one of our participants. Otherwise, you might need to follow up with your accounting and payroll partners if you're subject to these provisions. And we will try to stay pretty general. There are a lot of unique circumstances. So if you have really specific questions about your workforce that might delve into your unique policies, or especially if there's something that is going to talk about any of your employees' medical conditions or personal situations, we really encourage you to talk to us offline about that so we don't have any confidentiality concerns. We did receive a question this morning related to unemployment benefits at this time. That is out of scope for this session, but I am happy to follow up with you offline to answer those questions and things that we don't talk about today. So I'm okay. Can you see the presentation?
Yes, I wasn't hearing you there for a minute, but now I can hear you.
Okay, perfect. Yeah, it was muting me, so I apologize. This lifeboat is here intentionally for two reasons. One, we're all in this together and to keep each other afloat. So that's the first reason that you can see the lifeboat. But I also thought it was important to share that this is the intention of the legislation. Sometimes we think of laws as things being done to us and creating more compliance, which may be true, but the spirit of the Families First Coronavirus Response Act was really to keep employees working and keep them on payroll and not force employees from having to choose between a paycheck and abiding by public health measures that avoid the further spread of the virus. So I think sometimes it's helpful to know the spirit behind legislation. And I would add that this law was written and passed very quickly. So now the Department of Labor and the IRS and other agencies are working to build the specific guidance of how we're going to comply. And it's literally changing every day and every hour. There are even some things we anticipate coming out today, and we'll talk about that in a moment. And I am trying to figure out how to advance my slide. Okay, so the agenda is going to be some introductions and then an overview of the legislation. Then we have examples and scenarios, and I'm happy to take questions along the way. I am having difficulty seeing all of the participants in the chat while looking at the presentation. So Lexi, is it possible that people can just unmute themselves and chime in if they have a question? Okay, thank you. Why don't I turn it over to Erin Borisoff to introduce herself, and then we'll go to J. Michael, and then we'll dive back in.
Good morning, everyone. My name is Erin Borisoff. I'm a partner with Par Ritchie, which is a law firm that originates in Lebanon, Indiana, and we have offices also in Indianapolis and Chicago. J. Michael and I have spent a lot of time over the last 2 or 3 weeks dealing with a variety of issues relating to COVID-19 and the impact to businesses and employers and employees. And so we're happy to be here today to hopefully answer some questions and be very upfront with you when we don't know the answers because the answer is not clear yet.
Thank you. J. Michael? J. Michael, are you able to unmute yourself and do an introduction?
Okay, there we go. Can everybody hear me now?
Yes, thanks.
Okay, wonderful. My name is J. Michael DeWeese. I'm an associate attorney with Parr Ritchie in the Indianapolis office. As Aaron said, we've been keeping a very close track of not only the legislation as it's come through, but guidance as is issued by the Department of Labor and maybe some other federal agencies throughout this time. Handle a lot of employment labor law issues for the firm. So this is obviously very relevant and very new for a lot of employers. So happy to be here this morning, and as Aaron said, to hopefully answer some questions if I can, or help out in any way, just understanding that some of this is pretty fluid and developing by the hour, sometimes literally. So happy to be here this morning and help out.
Thank you. And I am Shawna Lake, the founder of Deepen Talent Strategies. I have over 20 years of human resources practice and consulting in the central Indiana area, and am a Boone County employer. I wanted to kick us off with a few opening thoughts. As business leaders, we're always trying to plan and prepare for unknown situations, but today we're a little bit past preparation and we're all in full adaptability mode. And we're having to set some strategic plans aside to just figure out how to stay in business and take care of our people. But this will end. We don't know how or when, but social distancing and isolation will end and we'll resume to some new normal. But it's my opinion that how you treated your employees during this time will transcend the crisis. And employees will remember how you enabled them to work from home with technology. They'll remember that you paid them as long as possible. They'll remember that you expressed concern for their safety and their health. And if you had to lay someone off, they'll remember the empathy that you displayed while telling them how valuable they are. And they'll likely want to remain a customer and hopefully work for you again in the future. We had some really good advice from Hallie on Wednesday's webinar, if you were able to listen in, about how leaders are being looked at by their employees. And it's important to set a good example, but it's also important to be authentic, and it's okay to show vulnerability and say you don't have the answers to all of their questions because this is all unfolding so quickly. Your North Star should be public health guidelines, and we're trying to then follow those with adapting employment laws. And you need to balance that with the workplace culture that you want to create and maintain. I think that it's a great time to engage your employees to help create creativity, unique schedules, get their ideas of how to keep your business running and even grow in this time, because no one is as smart as all of us. And as leaders, there are always two considerations that you need to make. It's what you can do, so what the law says or what you're allowed to do by agreements, and then there's what you should do. And I think it's important to balance those two. And I would encourage you to have thought partners in your life and in your business so that you don't make knee-jerk reactions while we're trying to adapt so quickly in this very dynamic environment. So I'm going to dive into an overview of the Families First Coronavirus Act. It was passed into law on March 18th, and the guidance said that it would go into effect no later than 15 days, which was April 2nd. But because things are changing so quickly, on Wednesday, the Department of Labor said it's actually going to go into effect on April 1st, but there will be a 30-day non-enforcement period for employers who are working in good faith to comply with the legislation. And we're going to talk primarily about the emergency paid family leave, excuse me, the emergency paid sick leave, then the refundable tax credits to offset your costs to offer those benefits. There are some notable other elements of the legislation. Excuse me, the FFCRA requires group health plans, whether you are fully insured or you're self-funded, to cover FDA-approved COVID-19 testing and provider visits for testing and evaluation of the virus, as well as telehealth and ER visits for testing or evaluation of the virus. You cannot have any pre-existing condition clauses, any co-pays, no other caveats, no out-of-network or pre-authorization penalties. So that is important. But if you have a health insurance plan, your benefit brokers or your PEO should be guiding you through those making those changes. There are also some expanded unemployment benefits, and there are some additional, I believe that we'll be seeing some even more unemployment guidelines coming in the next few weeks or even days. And then there's some additional Medicaid funding and food assistance. But we're going to focus on this emergency paid leave, emergency paid sick leave, and the tax credits. So the Family and Medical Leave Act, or FMLA, was expanded with this emergency element to cover someone who can't work or telework because they have a son or a daughter with a school or a daycare that's been closed. If you're not familiar with FMLA generally, it is up for employees or employers who have 50 or more employees in a 75-mile radius. And to be eligible, generally, employees need to have been employed for 12 months and worked at least 1,250 hours in the past 12 months to be eligible. And it covers the birth or adoption of a child, placement of a child for adoption or foster care, if you need to care for an immediate family member with a serious illness, or you have your own medical condition. And it allows for needs that arise from someone having a approved military active duty service. So that's the general FMLA. And small businesses with less than 50 employees don't probably have procedures in place and forms because they don't have to comply with FMLA. But the emergency FMLA that's been expanded under the FFCRA is now covering employers with fewer than 500 employees, including tax-exempt organizations and public entities. And it applies to all employees who have been employed for 30 calendar days. Healthcare providers and emergency responders may be exempt, and businesses with fewer than 50 employees may be exempt if granting the leave would, quote, jeopardize the viability of the business. And we anticipate that being clarified and getting some understanding from the Department of Labor of what that actually means today, in the near future, but possibly today. And this 12 weeks is job protected leave between April 1st and December 31st. Again, if someone has a son or a daughter who has a school or a daycare that's been closed, and that's resulting in the employee not being able to work or telework. I'm going to pause and see if either J. Michael or Aaron want to add anything there, or to see if there are any questions.
Shawna, one thing that I would add, you mentioned the potential exemption for a business with 50 or fewer employees if it would jeopardize the viability of the business. You did say that DOL is going to be issuing further guidance on this, but I think it's important for employers who are under 50 employees to understand that we expect this to be a more case-by-case type of exemption. And so just be very careful not to assume that this would apply to your business, and just take a lot of precaution if you're looking at that exemption, with the understanding that the Department of Labor will probably issue a little bit more clear guidance soon, hopefully.
Thanks. Some of my peers that I've talked to are anticipating that it's going to be a high bar to meet because they really want to put this protection in place for employees. But we'll hopefully find out soon. So thank you for that. A few more details for this emergency FMLA. The first 10 days are unpaid, but it can run concurrent with emergency paid sick leave that I'm going to talk about in just a moment. An employee can also substitute any accrued benefit time that they have during those first 10 days, but an employer cannot require them to do so. Then days 11 and beyond are paid at 2/3 of the employee's regular rate of pay. If someone, and that is capped at $200 a day or $10,000 total over those 10 days. If someone is hourly, you would think about the number of hours they're normally scheduled in a 2-week period. But if someone works highly variable hours or you've recently reduced hours, you need to do a 6-month look back to get an average of how many hours they would be owed in those first 10 days. Okay. I'm going to then take us to the emergency paid sick leave, which, excuse me, is the same applicability for employers with fewer than 500 employees, including tax-exempt organizations and public entities. It applies to all employees, whereas the emergency FMLA requires that you've been employed for 30 days. This has no minimum tenure. Again, healthcare providers and emergency responders may be exempt. And again, there's this mysterious exemption for employers with less than 50 employees if granting the leave would jeopardize the viability of the business. So this emergency paid sick leave is essentially covers those first 10 days of the emergency FMLA that's unpaid. And it pays the employee 100% up to $511 a day for a few reasons. Or if those don't apply, it pays the employee up to 2/3 of their pay, up to $200 a day. So the leave is at 100% pay if the employee is subject to a federal, state, or local quarantine or isolation order. It's unclear if this applies to everybody living in Indiana right now, given the governor's executive order from Monday. It is also paid at 100% pay if someone has tested positive or is experiencing symptoms of COVID-19 and seeking a medical diagnosis, or they've been advised by a healthcare provider to self-quarantine. So those are the reasons why those first 10 days will be paid at 100%. If none of those apply, then it's 2/3 pay if the reason is to care for a son or a daughter whose school or daycare is closed. And we have a couple of scenarios and examples to show how this works out. Are there any questions from people on the webinar at this point? Okay. Right before I get to those examples, I want to talk about the lifeboat of this legislation, and that's the tax credits. Employees can receive a 100% reimbursement for the paid leave that they pay their employees during this for these provisions, plus some costs for continuing healthcare benefits while the employees are on leave. And it's an immediate dollar for dollar tax offset against the payroll taxes that they would owe. I have some examples literally taken from the IRS, and they're on the Department of Labor's website at the link down below. So if an eligible employer paid $5,000 in sick leave and is otherwise required to deposit $8,000 in payroll taxes, which includes the taxes withheld from its employees, then the employer could use up to $5,000 of that $8,000 and that it was going to deposit, and you can use those $5,000 for making qualified leave payments to the employees. If the employer, and then the employer would only be required under the law to deposit the remaining $3,000 on its next regular deposit date. If an eligible employer paid $10,000 in sick leave and was only required to deposit $8,000 in taxes, then the employer could use the entire $8,000 of taxes in order to make those qualified payments and file a request for an accelerated credit for the remaining $2,000. Again, now those examples are on the Department of Labor's website. So let's get into some real life examples here. So Sam works full-time for an eligible small employer, and his infant son's daycare is closed. He's requested emergency FMLA and emergency paid sick leave. Sam has 5 sick days available from his regular annual allotment, but he wants to save them for possible use later in the year. So Sam applies for FMLA and is approved. His first 10 days are unpaid under the FMLA, but concurrently, the paid sick leave would provide 2/3 pay because the daycare is closed. Now, here's a question mark that we're all trying to work through. If Sam is subject to an isolation order, it'd be paid at 100% pay. And we're still a bit unclear on that. So weeks 1 and 2 are emergency paid sick time paid at 2/3 or 100% if it's due to an isolation order. And it runs concurrent with the first 10 days of the emergency FMLA, which is unpaid time. And then weeks 3 through 12 are FMLA leave paid at 2/3 through the 12th week or when Sam can return to work. Are there any questions about that example?
I have a question.
Okay, go ahead.
We have 2 or 3 people that are actually working from home now. Their hours may be cut back a little bit, but for the most part, everything else is normal. Am I to assume that would be not applicable compared to anything you're saying? As long as we're continuing to pay them, they're happily working at home.
Yes, if telework is an option, then that's the preferred. And this is only if someone is unable to work or telework. Yeah, great question. Thank you.
Thank you.
Others? Okay. Our next example is about
Hey,
Seth.
Shawna.
Seth works. Oh, go ahead. Yeah.
Sorry, there was a question that came through the
Oh.
chat, so I just thought I would tell you what it was.
Thank you.
Okay, the question is, we had an hourly employee who had to be home to take care of kids since his wife is a nurse and they lost their daycare worker because of the governor's order. We encouraged him to apply for unemployment and told him we want him back on board as soon as he can come back. Would it be recommended to bring him back on board April 1st and pay him leave?
I'm going to see if J. Michael or Aaron have a thought on that. I'm sure that they do. The obligation, if someone's an eligible employer for this, for the emergency FMLA and the emergency paid leave, you only have to comply on April 1st or after. So if someone has been separated from employment up until that date, they don't have to do this. Should they choose to bring somebody on and grant the benefit, it might be a business decision. And I'll let J. Michael and Aaron see what they might add to that scenario.
I'm going to chime in first, and then I'll let J. Michael follow up with anything else. One concern I would have for you as the employer in this situation is that the expanded FMLA, which gives the benefit for weeks 3 through 12, applies to employees who have been with the employer for at least 30 days. And unfortunately, it's possible right now that if you brought this employee back on because they've been separated, now they have not been with you for 30 days. And the tax benefits may not apply to this employee. So I'm going to give you the most frustrating answer ever from an attorney, which is it depends, and it may be a little bit gray, and you may be at risk for not getting the tax benefit for this particular scenario.
J. Michael, were you going to add something?
I suppose the only thing that, if everybody can hear me, I think I've unmuted this. I'm learning the whole Zoom thing here. So the only thing that I would add to that is, the leave is not retroactive, I think, as has been stated. It begins to apply April 1st and moving forward. There will be some questions because there hasn't been clear guidance from the Department of Labor issued on this yet. Also, the regulations that the Secretary of the Department of Labor has been authorized to implement have not been issued yet, that may otherwise clarify this too. But there could be some question about, what type of employment status, what type of leave an individual may be on between now and April 1, and whether or not they would be able to avail themselves of this emergency FMLA, even if they have not been working over the last week or two, because they've had to take an unpaid leave or they've had to use built-in sick days that they've got in a bank or whatever. So there will definitely be, hopefully, further guidance issued on this. But at this time, as Aaron has said, it remains a little unclear as to how that would apply. And it's going to be really specific based on the type of situation that you have with an employee that might not be working right now.
Thank you. Okay, so this next example is about Seth. He works full-time for an eligible small employer with less than 50 employees. He has tested positive for COVID-19. He requests emergency paid sick leave, and Seth has the same 5 sick days available, but he wants to use them before taking the emergency benefits. So Seth takes his first 5 days as paid sick leave and then initiates his emergency paid sick leave. So week 1 uses those 5 accrued sick days. Weeks 2 through 3 are emergency paid sick time paid at 100%. And then after that, Seth is not eligible for emergency FMLA because the absence isn't a result of a school or a daycare closing. It's his own illness, but his employer is not subject to the standard provisions of the Family and Medical Leave Act. So at that point, Seth can be on unpaid leave. Some companies are doing leave donation programs where you can have other employees donate available time to employees, and looking for some creative solutions. But Seth is not eligible for the emergency FMLA.
Shawna, one point about all of what you just said, I think that example is a really good example for employers to think through also which of, not only what leave Seth would be eligible for, but also which of these weeks the employer will be able to hopefully obtain the tax credit. And so just, if it's probably obvious, but week 1, he's using his already accrued sick days, and those would not be eligible for the tax credit. Weeks 2 and 3 are the emergency paid additional leave, and that is eligible for the tax credit. And then weeks 4 through whatever, any sort of creative solutions that the employer would come up with would likely not be eligible for any sort of tax credits.
Thank you. Okay, so Judy has also tested positive for COVID-19. She requests emergency paid sick leave, and she also is not eligible for emergency FMLA. Her weeks 1 and 2, are emergency paid sick leave paid at 100%. And then starting in week 3, she may use any available benefit time or unpaid leave until she can return to work. But let's say in week 4, Judy's doctor says that she's well and she's able to return to work. So here's some audience participation. Can you ask for a doctor's note before she comes back to work? Feel free to signal with thumbs up, thumbs down, or unmute and chime in. Okay, well, yes, you can, and that would be advisable. Next question, which opens a whole can of worms. Can you take her temperature when she arrives back to work on that first day? What do you think?
I would say as long as you're doing it with everybody.
Nice. Yes. The EEOC, the Equal Opportunity Commission, issued official guidance that yes, in fact, you can do that. A month ago, people may have said that that was prying into someone's medical situation and would have been risky, but we are all in uncharted waters right now. But at the same time, experts have said not everybody who has symptoms of COVID-19 shows a fever, and not everybody with a fever has COVID-19. So sometimes you need to be careful about the information you do get. And if you are gathering this information, you still have an opportunity to protect the employee's confidentiality. And if you're writing down the results of taking a temperature, you now are in possession of someone's protected health information, and you have obligations of how you store and protect that. So yes, you can. And then we're back to that guiding principle of sometimes there's what you can do and there's what you should do. And it's good to consult experts and get different opinions. Does anyone have anything to add there? Okay, let's stick with Judy for a second and build on this scenario. So Judy doesn't have a fever and she returns to work. Her employer is an essential business and telework is not an option for what they do. Jane normally sits next to Judy, and since Judy had been out sick and had told people she had COVID-19, Jane tells her supervisor that she isn't comfortable going into the office because Jane has been sick. So what steps can the employer take? And I'll open this up to Aaron, to J. Michael, or to anybody on the call. What do you think? What can you do and what should you do?
I'm deferring to J. Michael on this one because his response and answer is far more compassionate to Jane than mine was. So I'm going to let J. Michael give the response.
Okay, that's fair, Aaron. So, obviously we've got, if you look at the first part of this scenario, we've got a situation where the employer is an essential business, which would signal that the stay-at-home order issued by the governor is not at issue here. These individuals are still able to go into work, and telework is not an option, which tells me that they have to physically be in the office to perform their job duties that the business has given to them. In this type of a situation, I mean, ultimately, if we're just going to pull the thread and get to the end game, the company might have to make a difficult decision about, telling Jane, you're going to have to work. We're essential. We can't allow you to do telework. We need you here in the office working. However, my approach would be that during these times when there's really a lot of uncertainty and a lot of fear out there, and understanding that people handle that differently, it gets into what we discussed at the very beginning between what an employer can do and what they should do, and maybe what an employer should do here is try their very best to accommodate some sort of arrangement for Jane, whether that's moving her to a different area in the building, having her maybe not sit right next to Judy's workstation, however they could work that out. But unfortunately, ultimately, under this scenario, the employer might not have an option, and that means Jane might not have an option available to her, but the employer should try.
Thank you. Any follow-up comments or questions? Okay, so moving into a different scenario, I have gotten a lot of questions and comments from companies who said we have to reduce our costs because our revenues are down right now. And what can I do? And what should I do? And what's the difference between a furlough and a layoff? So a furlough is a mandatory, unpaid, and temporary leave. So when you put somebody on furlough, you almost always give them a return to work date at some point in the future, so they know how long they're furloughed. while someone is on furlough, they are eligible for unemployment benefits. And one of the benefits of a furlough over a layoff is that employees can jump right back in to the work when they come back. They're already trained. They already know all of your rules and procedures. You might just have to re-grant access and things like that. A lot of companies will choose a furlough over layoffs because they can keep a smaller scale operation going, but not have to shut specific services down. A special note here, though, if you are furloughing someone who is salaried and exempt, so exempt from the overtime and minimum wage provisions of the Fair Labor Standards Act, truly exempt, not just somebody that's hourly, but or someone who you pay a salary to, but they're truly exempt. You want to make sure you take back any cell phones, laptops, or any communication devices, because if someone is exempt and you call them or ask them to do anything while they're on a furlough, you owe them an entire week's pay. If your goal is to reduce your costs, you have worked against yourself there. So that is something that's it's a really common mistake, that people will furlough exempt employees and then still allow that employee to check email or to check voicemail, even if you're not reaching out to them. If they're doing it, that you have to make sure that they understand that they are not to perform any work or do any services during a furlough. A layoff is a full separation of employment. Hopefully, when you can rehire and rebuild your staff, you'll recall your laid off workers, but there's no time frame, there's no guarantee that you're going to do that. And sometimes a layoff comes with additional costs because you have severance packages or outplacement services, if you're able to offer those. And when you are rebuilding your staff, you have recruiting and you have training costs. So just a few things to consider there and the differences between a furlough and a layoff. I would always consult your legal counsel before doing either of them. There is, I don't want to get too geeky, but there is something called the WARN Act, which is the Worker Adjustment and Retraining Notification, which the state requires you generally to have to give advance notice if you're going to do a mass layoff or you're going to shut down. There are a lot of states relaxing those WARN obligations now in this current environment, but still check with your legal counsel. And if you have any union employees, you also need to check with them and work in close partnership with the union leadership. And if you're in a PEO, a professional employer organization, and you likely know if you are or you are not, PEOs are service providers who bundle smaller companies together for group health insurance benefits. They often do your payroll and can offer some HR consulting and advising. If you're in a PEO, you're in a co-employment relationship. So your employees are also employees of that PEO. So if you're going to take any action against them, you're also doing something to the PEO's employees. So you need to make sure you're working in close partnership with them. You also want to review any of your benefit plan documents, because if you cut somebody's hours or you change their employment status, you might be impacting their eligibility for benefits. And you want to make sure you know what your obligations are to inform your benefit plan providers. If you're a self-insured plan and you have reinsurance, you need to make sure you're also very aware of what your obligations are there.
Shawna,
yes.
I'd like to take this slide and apply it to Heather's question about the employee who basically had to stop working to take care of their child. So Heather, if you evaluate all of the facts about that employee, the benefits that they had, the manner in which that employee stopped working, the communication that you had with the employee about coming back. It sounds like you told them, we want you to come back as soon as possible. If you can evaluate all of that and it looks more like a furlough or unpaid leave and not a separation, then it may be possible to bring them back and have them qualify for the FMLA leave. The point is that there's a lot of different factors that need to be considered, but it is really important for you to go through that list and decide, have they been furloughed? Is this an unpaid leave going on right now, or did you really separate them from employment? So you may want to look into that further, especially because you have the situation that you'd like to be able to get them that leave.
Great consideration. Any other comments or questions? Okay. So our friends at Par Ritchie have also been getting a lot of questions, and they shared with me 4 that they're hearing a lot. So I'll read the question and then I'll allow them to talk about how they're answering that and advising their clients. So the first one is, does the scope of the stay-at-home order exemption for an essential business or operation apply to all employees of that operation?
So this is a question that has been asked by specifically by our utility clients, because utilities are definitely essential business operations. But the question was, just as an example, does the office staff qualify as essential business and operations? Does payroll, do the customer service representatives? And while we cannot definitively say how the state or a court or the IRS would interpret the governor's executive order, we believe that the employees that you employ as a business, we believe you probably wouldn't be employing them if they weren't essential to your operations as a business. And so all of the employees that you're employing are supporting your operations. And if your business as a whole is an essential operation, then your whole business is an essential operation and all employees. Again, our caveat on that is that's our interpretation. That is our based on the language of the executive order, based on some guidance from Department of Labor and federal agencies. And it's not definitive, but that's the guidance that we've basically been giving.
Thank you. The next question, maybe. If an employee is exhibiting symptoms of the virus, or they tell us they've tested positive, can we ask them, and what can or should we tell other employees?
I'm going to ask J. Michael to answer this one.
Sure. So we've already heard in the first part of this presentation, earlier parts about doctor's notes and taking individuals' temperatures. I'm going to answer this specifically as to if an employee has notified the employer that they have tested positive for the COVID-19. At that point in time, what seems clear is that from the guidance that we're getting from the different government agencies is that employers at that point should be taking steps to have that employee go and obviously do the quarantine, to stay away for the 14 days that is currently being advised. Of course, that's subject to change as they keep learning more about the virus, but certainly to stay away for that isolation period. As far as notifying other employees in the workplace, my comment on that would be the Center for Disease Control and some other agencies have made it clear that employers should notify the potentially exposed employees that they've potentially been exposed. Now, there is a smart, tactful, graceful way to go about that. And obviously, a way that an employer should go about that is to take their best efforts not to specifically identify, and I would say just simply do not specifically identify the employee who has tested positive, notify in a very general way potentially exposed employees and let them know that they've been potentially exposed. And, you know, there's guidance out there for those who have been potentially exposed on how they should proceed, how they should assess, and then what they should do in the next steps. But an employer should notify potentially exposed employees, keeping in mind considerations of privacy laws as far as identifying the positive tested employee, and just taking precautions to protect as many people as possible. And I believe it's those that came within 3 to 6 feet is the guidance of a potentially positive employee.
Thank you. Okay. Does the FFCRA impact our ability to do a layoff or reduce hours?
Again, I'll throw this one to J. Michael.
My answer to this question would be, employers are still going to have, the ability to take certain steps to protect the business, and whether those include layoffs or reduction of hours. The new act would not otherwise prevent that. What I would say is that it just opens up new avenues for employees to receive these expanded benefits, and that may be something that an employer is going to have to navigate. If you have people who have availed themselves of this new leave, the expanded leave, considering what a layoff or a reduction in hours might do after that point is going to be something that an employer will have to navigate on a case-by-case basis, looking at what they've got as far as their workforce. I would say employers need to be very careful about timing of layoffs, reduction in workforce, reduction in hours, as we are approaching the implementation date of this new expanded leave. And certainly, because there are very strong anti-discrimination provisions within these new expanded leave sections, the employer does not want to give the impression that the reason they have done a layoff or a reduction is to avoid having to offer the new leave. Employers should be very careful about that, consult with counsel. If there's a business justification, that should be explored. But certainly an employer doesn't want to give the appearance that they have taken action to try to skirt around the new federal law, as I'm sure there will be some scrutiny and a lot of examination from the Department of Labor on those issues in the next coming months. Just being aware that unfortunately there will be bad players in the system who may try to do that.
Thank you. So hypothetically, a business wouldn't want to lay off all of the people who are of an age to have daycare children, for example.
Yeah, so I would say that anything that's going to lend itself to an appearance of discrimination. Now, obviously, there can always be independent business justifications, but I think what we're going to see, what I would predict to see come out of this is some pretty, there are harsh penalties for someone who violates the provisions of the act, that being an employer, as far as, damages that have to be paid and so forth. But I would say that they're going to be looking very closely at actions that employers take, especially these new employers who are suddenly subject to these provisions that never before have been. They're going to be taking a look at, does it look like the employer just started laying people off so they didn't have to offer this? And if so, I think the world of hurt that could possibly that person could exist in is worse than if they had just offered the leave to begin with.
Thank you.
Shauna,
Okay. Oh,
we
yes.
do. I'm sorry, I keep interrupting you.
No.
Luann Clough has a question. So it is, what are the best resources for determining / utilizing the tax credits?
The best resources to get additional information. Perhaps when in a couple slides, I have a list of resources and links. One is to the Department of Labor with some of this tax guidance. So if we could maybe table that for a moment, see if the link is helpful and answers it. And if not, we can come back to that at the end. Thank you. And then the last question here for Par Ritchie, at least immediately, is can we take preventative steps to protect our pregnant or older workers?
So on this question, we heard this question several times from employers about 2 weeks ago, before a lot of employers took steps to facilitate working from home. And so I think this question has kind of died down, but for those employees who are still cannot telework and are needed in the office or at the work site, the answer is you cannot take discriminatory steps to prevent or to protect pregnant or older workers, because unfortunately both of those are in protected classes, and if your well-meaning efforts to protect them look like potentially adverse employment actions, you could be in trouble. And so what I would say is, if your pregnant or older worker is requesting and very much wants the protective measures, then by all means do that. But if your pregnant employee or your older employee is, saying, no, I don't want to be treated differently, or especially I don't want you to be segregating me or sending me home, I would say that while you are well-meaning, you should probably respect what they're saying at this point, because we do have age discrimination and disability discrimination laws that prevent us from treating them differently.
Thanks, Erin. So I want to be careful with our time and leave a little bit of space for questions. Really quickly, there are a couple of safe harbor provisions here. One is the information we're still waiting on as to what qualifies jeopardizing the viability of the business for companies who have under 50 employees. And then there is also a safe harbor provision that for companies who have less than 25 employees, if they grant the emergency FMLA, they don't have the same reinstatement obligations to reinstate an employee back into their original position. And those are pretty situational, so I don't want to go into too much detail. I do want to get into this compliance steps, or what I would otherwise title this is, what do you actually need to do right now? And the first is to write written leave policies if you don't already have them, or update existing policies to refer to the emergency FMLA and the emergency paid leave. You can Google sample policies. They're out there in several places. And I actually, on my website, I have sample policies you're welcome to copy and customize for your business. You also need to distribute those policies to all of your employees. And then probably the number one thing I would recommend that you do is add this required notice from the Department of Labor wherever you display your labor law posters. And I will show you a link to that poster. It is ironic that you need to post it with your labor law posters, but most of our employees are remote right now. So the best practice would be to email it to your employees and make them aware, or post it to an intranet site or someplace where everybody can access it. And this is making your employees aware of these provisions under the Act. That's all that you need to do in terms of informing your employees of the benefit. you are not obligated to go seek them out and try to enroll them in these plans. You make them aware that they exist, and then then the burden is on them to request these leaves. We already talked about coordinating with your PEO if you have one in union leadership. And then I started off by saying you're going to want to work very closely with your legal counsel and your accounting and your payroll partners. And then we also talked about knowing your benefit plan documents. Be aware of what employment actions you might take that trigger eligibility for benefits, what might trigger COBRA, and also 401k. Some of your benefits have a required number of hours that someone needs to have worked in a certain period of time. And so it's just really important to know what unintended consequences there could be to benefit plans for some of the necessary employment actions that you might need to take. This slide deck and webinar will be available to everybody, so you can access these links, or you're welcome to take a screenshot if you want. These are just a few of hundreds of available resources online right now to help employers. The tax guidance is the second to last one that might answer Luann's questions. And number 5 is the required labor law poster. So that link will take you directly to that poster. This is for non-federal employers. There is a special version if you're a federal employer, but this also at that same location. So if we aren't connected on LinkedIn, I'd love to be connected with you. If you want more information about Deepen Talent Strategies, we do have a company LinkedIn page and an Instagram. My personal stretch goal this year is getting more comfortable with Instagram and using that as a way to communicate with clients. So I'd love to follow you and have you follow me as well. And then on my website, I have a tab called COVID-19 Employer Resources, where you can find sample policies and a lot of other tips as well. And this is the contact information for Aaron and J. Michael and Par Ritchie as a great local law firm that can help you with a lot of these special questions. Aaron or J. Michael, do you have any closing comments?
No, thank you very much for the opportunity. And we understand that this is difficult, and we're managing through it just like everybody else.
Yeah, I would just say I won't take up a bunch of time with it, but I didn't want to insert myself and interrupt whenever we were going through all the stuff about layoff and furlough. Just so you know, employers should be aware. It is something that we have been discussing about this issue of layoff and how that's a separation from employment. For those of you employers out there, you should just be aware that taking that action in a layoff, there is some authority out there to say that that would trigger some of the provisions of the Indiana wage statutes, where when an employee is separated from their employment, they're entitled to wages for hours worked at the next regular payday. Just be aware that based on the way your documents are worded there at the company as far as the benefits, that next check could potentially have to include some benefits pay depending on the situation. Wage claims can be costly. I have seen them from both the plaintiff and the defendant's side. So just make sure you're consulting with your HR, your policies, your counsel, if you should have to take the action of laying off employees, to understand how that might impact you with other areas of law that we really did not discuss on this webinar this morning, just because it was sort of outside of the scope, and there's a lot to consider and think about. So just being aware of that, and I appreciate the time to be here, and I'd be happy to answer any follow-up questions that anyone has, as Aaron has said. Thank you.
Thank you for that. So I know we're at time, but I'm personally available to stay on if there are questions or follow-up offline.
I have a question.
Okay.
In light of the state and national legislation that is recently passed or in the process of being passed, might we expect a change in the tax tables, for instance, with QuickBooks, and will those be reflected automatically? Are we even going to get a change in the tax tables? Can you play that out for us a little bit?
I certainly don't know, and I'm not qualified to answer that question. I don't know if Aaron or J. Michael is, or if we have a tax professional as a part of this webinar. Again, nobody is as smart as all of us. So is there anybody who feels comfortable diving into that?
Kim Storin, are you still on this call? I think I saw your name. Everyone feel free to unmute if you want to speak. But I thought I saw Kim, if she's still on here.
Sounds like a question for my CPA then.
Yeah, I know there are going to be a lot of questions. I think that our CPA friends are probably getting a little overwhelmed right now. There are also some benefits for self-employed individuals, and my understanding is that those can be reflected in quarterly tax payments this year, which is again another question for a CPA, but they're gonna be pretty busy. Any other thoughts on that topic or other questions?
I have a question.
Okay.
So the majority of my staff are minor employees under 18. How do all these provisions affect them?
I have a thought, but it looks like J. Michael wants to jump in. I'm going to let him do that.
Yeah, so I guess the question, if I'm understanding, would be whether there is a distinction to be drawn or any differences based on minor employees or otherwise. I would say that the definition of employee under these new provisions is just going to simply be whether or not the person is working hours for an employer, kind of going back to the basics of just employer-employee definition. I don't know that there is any difference there unless you have a specific question that you're asking about how would some of this apply to a minor employee, if there's something in like the stay-at-home order you're worried about or otherwise. But if it's just a distinction between whether minor employees would receive a different benefit from adult over the 18 employees under these, I don't know that I see that within the regulations to draw a distinction there.
To the extent that these employees are part-time, the benefits afforded both under the Fair Labor Standards Act, so the additional sick time, and then the FMLA would be prorated in terms of how much leave you have to provide to them. So that's one thing to keep in mind, which I don't know that we didn't really break that down specifically here, but part-time employees get prorated benefits.
Yeah, thank you. And the only other thing I would add is that the emergency paid sick leave would obviously apply to any of your employees who become ill, but the emergency FMLA is only applicable if someone has a son or a daughter who's at a daycare or a school that's closed. So it's not completely unreasonable that you could have a 17-year-old or 18-year-old employee with a small child, but I'm going to go out on a limb to say your minor employees are probably less impacted by a school or a daycare closing. Other thoughts or questions? Okay, well, I am certainly happy to answer any questions via email, or you're welcome to call me, reach out on social media. However, I can be of service to help people in this really dynamic environment. And I again appreciate the Chamber and the opportunity to talk with you all today and to partner with Aaron and J. Michael. Parrici has been a fantastic partner in this webinar. So I'm going to wrap it up and turn it back to Diane.
Thank you, Shawna. You know, again, thank you to Shawna and J. Michael and Aaron. We greatly appreciate our chamber members' expertise. We all know this is a lot of information and so many different scenarios for individual businesses. So again, feel free to contact Shawna or Aaron or J. Michael, or your HR expert that you do business with, your CPA, or your legal advisor to get specific information for you. As our presenters today clearly stated, you know, there's a lot of ramifications if we are all not doing what we need to do, and it's a lot of information. So we most certainly want to empower the expertise of those, you know, that have that knowledge. Our role is to connect you with those experts, and we hope that we have been able to do that today. Please shoot us an email. My email is D for Diane, and then Schultz, SCHULTZ, at boonechamber.org. And, you know, I can connect you, you know, with resources if I have those too. Let us know your thoughts on today's webinar. We would love to hear from you. And again, if there are topics that you want information on, we will utilize those topics for further webinars. So thank you again. We know that we're all in this together. It definitely is a time of uncertainty, but we're very proud that we've been able to bring together chamber and community members. And I think that's really what's going to help us really get through this in a positive manner. You know, we hope that this is short term as possible, that we can all get back to business as we would like to do. But in the meantime, we're really glad that we could connect with you virtually today. So join us for future webinars also.